Before we get into the video, could everyone please subscribe to my HOA Karen Tales channel? Thank you so much. I never thought I'd find myself in a legal battle with my own homeowners association, but here we are. My name is Michael Lawson, and until 6 months ago, I was living what I thought was a peaceful life in the Oak Estates community. I've been a district court judge for nearly 15 years, but I've always kept a low profile in my neighborhood. I prefer separating my professional and personal lives, or at least I did until Deborah Wilson, our HOA president, decided to make my 1967 Mustang convertible her personal crusade. It all started last summer when I finally finished restoring my father's vintage Mustang. It was a gorgeous midnight blue with pristine chrome work that took me 3 years of weekends to complete. Dad had passed away 5 years earlier, and restoring his pride and joy was my way of honoring his memory. The car wasn't just a vehicle. It was a piece of family history, countless hours of bonding time, and irreplaceable memories. The first sign of trouble came on a Tuesday morning as I was leaving for work. A white envelope was tucked under my windshield wiper, an HOA violation notice. Vehicle in violation of community aesthetic standards must be stored in garage or removed from property within 48 hours. I was baffled. My driveway was spacious, the car was in immaculate condition, and nothing in our HOA bylaws prohibited classic cars from being parked in driveways. I called the HOA office that afternoon and spoke with Deborah herself. Mrs. Wilson, I've reviewed our covenants, and there's nothing prohibiting restored classic cars from being parked in private driveways, I explained calmly. Her voice was cold and clipped. Mr. Lawson, the board has recently reinterpreted Section 8.3 regarding vehicles of unusual appearance. Your antique falls under that category. The decision is final unless overturned at the next quarterly meeting, which is 3 months away. I took a deep breath. I'd like to request a special meeting to address this interpretation. It seems to be applied arbitrarily. Request denied, she snapped. The board is not obligated to hold special meetings for individual complaints. Remove the eyesore or face escalating fines. She hung up before I could respond. That evening, I noticed Deborah slowly driving past my house, taking photos of my car with her smartphone. Our eyes met, and instead of showing any embarrassment of being caught, she gave me a smug smile and waved. I should have recognized the warning signs then, but I honestly didn't think anyone could be so petty over a well-maintained classic car. The following weekend, I was having coffee on my front porch when Deborah marched up my walkway with a middle-aged man in tow. "This is Roger from the Architectural Committee," she announced without greeting. "We're documenting continued violations." I set down my coffee. "Good morning to you too, Deborah." "Roger, nice to meet you. I'm still waiting for clarification on which specific bylaw my car is violating." Roger at least had the decency to look uncomfortable. "Well, Section 8.3 does mentions vehicles in visible disrepair and commercial vehicles, neither of which applies to my restored classic car." I interjected, "I've read our bylaws front to back multiple times." Deborah's face flushed. "The board has discretion to interpret community standards. Mr. Lawson, this isn't a courtroom where you can argue technicalities." If only she knew. Actually, proper procedure and clear interpretation of written rules are important in any organized society. "Deborah, I'm simply asking for consistent application of our agreed-upon covenants. Your car is an eyesore that's reducing property values," she insisted. "Multiple neighbors have complained. May I see these complaints? Our bylaws require documented grievances for violations." Roger shifted uncomfortably while Deborah's eyes narrowed. "Those records are confidential. The fine is now $100 per day, retroactive to the first notice." They turned and left without another word. I spent that afternoon knocking on neighbors' doors. Not one person had complained about my car. In fact, several neighbors admired it and had asked for rides. Mr. Henderson, the retired mechanic next door, had even helped me with some of the restoration work. Something wasn't adding up. The next morning, there was another notice on my windshield, this one warning of imminent towing if the vehicle wasn't removed within 24 hours. I immediately sent a certified letter to the HOA board formally contesting the violation and requesting proper documentation. I also installed a security camera focused on my driveway. Something told me I might need evidence soon. The following day, I had to leave town for a judicial conference in Chicago. I considered moving the Mustang to a storage facility while I was gone, but on principle, I refused to be bullied over something that wasn't actually violating any rules. I asked Mr. Henderson to keep an eye on things while I was away. 3 days later, I received a frantic call from him. "Mike, they towed your car this morning. That Deborah woman was here with a tow truck at 7 a.m. I tried to stop them, but she had some paperwork she claimed gave them authority. I took pictures with my phone. I felt a cold knot form in my stomach. Thanks, Dan. I'm flying back tomorrow." Did they say where they were taking it? Some impound lot across town, citywide towing, I think. Deborah was practically gloating, saying something about rule breakers learning expensive lessons. As soon as I landed the next day, I drove straight to citywide towing, only to discover something that made my blood run cold. My car wasn't there. According to their records, the Mustang had been claimed by the HOA through something called abandoned property disposition after being impounded for just 24 hours. "That's impossible," I told the clerk. "It wasn't abandoned. It was illegally towed from my private property while I was out of town for work." The clerk looked uncomfortable. "If we just store the vehicles, if someone comes with the right paperwork, we have to release it. You need to talk to whoever authorized the tow." I immediately drove to the HOA office. The receptionist informed me that Deborah was out for the day, but confirmed that my car had been processed according to HOA bylaws regarding abandoned vehicles. When I demanded details, she handed me a copy of an auction notice. My stomach dropped as I read it. My father's Mustang had been sold at a private auction for $7,500, a fraction of its $60,000 value. Just that morning, who purchased it? I asked, my voice barely controlled. "I'm not authorized to disclose that information," she replied, not meeting my eyes. "I need to see the documentation authorizing this sale immediately," I insisted. "You'll have to file a formal request with the board. The standard processing time is 30 days. I placed my business card on her desk. "Please inform Mrs. Wilson that Judge Michael Lawson will be filing an emergency injunction first thing tomorrow morning. If all documentation isn't on my desk by 9 a.m., make sure she understands this is not a request." The receptionist's eyes widened as she finally made the connection. "You're a judge?" "Yes, and while I've tried to resolve this reasonably as a neighbor, it appears the HOA prefers the legal route. Please make that call now." I spent that evening reviewing my security camera footage, which clearly showed the tow truck removing my car without proper notice. I also collected statements from 5 neighbors confirming they had never complained about my vehicle. By morning, I had the framework for not just an injunction, but a substantial lawsuit for illegal conversion of property, procedural violations, and fraudulent misrepresentation. At 8:45 a.m., my doorbell rang. Deborah stood there, a manila envelope in her hands and a sour expression on her face. "You should have mentioned you were a judge," she said accusingly, as if I had somehow tricked her. "You never asked about my profession, Deborah, and more importantly, my occupation shouldn't matter. The HOA is required to follow proper procedures with all residents." She thrust the envelope at me. "Here's your documentation. The car has already been sold, so there's nothing to be done now." I took the envelope but didn't open it. "Who purchased the car, Deborah?" She hesitated. "My brother-in-law. He's a collector and recognized the value opportunity." The pieces suddenly clicked. This had never been about community standards. It was a scheme to acquire a valuable classic car for pennies on the dollar. "So you personally benefited from the illegal seizure and sale of my property? That's very interesting." For the first time, uncertainty flashed across her face. "The procedure was completely legitimate under our bylaws." "We'll let the court decide that," I said calmly. "Please inform your brother-in-law that the vehicle he purchased was stolen property sold without legitimate authority. He should prepare to return it immediately. He's already transported it to his home in Tennessee." She replied with a hint of smugness, returning, and the sale was final. "Check your bylaws, section 12.9. I nodded, thought, interstate transport of stolen property. That elevates things considerably. "Thank you for that information." The color drained from her face. "Are you threatening me?" "Not at all. I'm simply informing you of the legal implications of your actions. Now, if you'll excuse me, I have some calls to make. My first call was to my colleague, Judge Martin, in the county where Deborah's brother-in-law lived. My second was to the State Attorney General's office, where I still had contacts from my prosecutor days. By that afternoon, local police had located and impounded my Mustang pending investigation. The HOA board called an emergency meeting that weekend, conspicuously without Deborah present. They were suddenly very concerned about procedural irregularities and potential liability issues. I attended with my attorney, a specialist in property law who happened to be a car enthusiast himself. Gentlemen, ladies, I began. I've spent over 30 years upholding the law, first as an attorney, then as a judge. I understand the value of rules and governance. What I witnessed here wasn't governance. It was theft disguised as procedure. The board members squirmed uncomfortably as I laid out the multiple violations of state property law, HOA procedural requirements, and potentially criminal actions involved in the seizure and sale of my vehicle. We were under the impression that proper notices had been issued. One board member offered weekly. My attorney slid copies of the security footage stills across the table. My client received one warning with no specifics about the alleged violation, followed by a towing notice less than 48 hours later. The vehicle was then towed while he was away, held for just 1 day instead of the legally required 30, and sold to the HOA president's family member for less than 15% of market value. No effort was made to contact the owner, despite having his contact information on file. Another board member paled. We didn't authorize any of this. Deborah said she was handling a routine abandoned vehicle case. That's interesting, I replied, because the documentation I received clearly has board approval signatures, including yours, Mr. Phillips. I pointed to his signature on the auction authorization. These were standard renewals for landscaping contracts, he stammered. I trusted. The meeting ended with the board offering to cover the full market value of my car, plus my legal expenses. I declined. This isn't about money. It's about abuse of power and violation of trust. I want my car returned, a formal apology issued to the community, and Wilson's immediate removal from the board. 2 days later, my Mustang was back in my driveway. The HOA issued a community-wide notice acknowledging serious procedural irregularities, violations, and announcing a special election to replace the entire board. Deborah resigned before she could be removed, but that didn't spare her from the consequences of her actions. The district attorney declined to press criminal charges after Deborah agreed to pay substantial restitution and perform 200 hours of community service. However, her real estate license was suspended pending a state ethics investigation. Apparently, this wasn't her first exploit in questionable property dealings. The most satisfying moment came during the HOA's special election meeting, where I was unexpectedly nominated to serve on the new board. As I stood to address the packed community center, I noticed Deborah slipping into the back row. I've spent my career ensuring that rules are applied fairly and transparently, I told my neighbors. I believe in governance that serves the community, not personal interests. Our HOA should protect our neighborhood's value and character while respecting individual property rights. We can have beautiful, well-maintained homes without resorting to petty tyranny. The applause was gratifying, but the look on Deborah's face as she realized her community standing was irreparably damaged was the true vindication. That weekend, I invited the entire neighborhood to an informal driveway gathering beside my now famous Mustang. Over 40 neighbors showed up, many bringing their own classic cars or unique vehicles they had previously hidden in garages for fear of HOA reprisals. Mr. Henderson brought his restored 1955 Chevy, and Mrs. Chun proudly displayed her custom-painted Volkswagen Beetle. As we shared stories and admired each other's prized possessions, a new sense of community emerged, one based on sharing our passions rather than policing our differences. Even Roger from the architectural committee showed up, somewhat sheepishly, in his vintage Corvette that he admitted had been gathering dust in his garage for years. I always wanted to drive it more, he confessed, but Deborah said it would violate the community aesthetic. Well, I replied, handing him a soda. It looks like our community aesthetic just got a lot more interesting and authentic. 6 months later, our new HOA board has rewritten the bylaws with clear, reasonable guidelines that protect property values without micromanaging residents' lives. We've established transparent procedures with multiple checks and balances to prevent future abuses. Most importantly, we've created a community mediation process that encourages neighbors to talk through concerns before filing formal complaints. My Mustang still sits in my driveway most weekends, though now it's often joined by other classic cars as our informal car club has become a neighborhood fixture. Sometimes I take the local kids for rides around the block, building new memories with my father's beloved car. As for Deborah, I hear she's moved to a condominium downtown, one without an HOA. The irony isn't lost on me. Most important legal lessons happen outside the courtroom, right in our own driveways. Last month, I received an unexpected letter from Deborah's brother-in-law. He's a genuine car enthusiast who had no idea about his sister-in-law's scheme. He wrote to apologize and enclosed old photos of his father's Mustang from the 60s. We've since met for coffee, and despite the awkward circumstances of our connection, we've found common ground in our appreciation for automotive history and family legacies. It's a reminder that even in conflicts that seem irreconcilable, there's often room for understanding if we're willing to look past our initial assumptions. That principle serves me well both in my courtroom and in my neighborhood. Justice isn't always about punishment. Sometimes it's about restoration. Whether it's a classic car or a community sense of trust, every time I pull into my driveway now, I think about how close I came to losing a piece of my father's legacy, but also about the unexpected ways this conflict strengthened my connection to my community. My car isn't just parked in my driveway anymore. It's home, exactly where it belongs. A symbol of standing up for what's right, even when it would be easier to back down. And if you're wondering what happened to that vehicle of unusual appearance clause in our HOA bylaws, we clarified it to apply only to vehicles that are actually in disrepair or abandoned. Because sometimes the things that make our neighborhood special are precisely those unique treasures we each bring to it, even if they happen to have four wheels and a story behind them.